new watch, new bells.
Mic check 1 2 1 2. What's good, TMG fam? It's your boy L, and I'm back with another reaction. How y'all feel? Welcome back to the channel. Salute. So listen, man, today I think I got another good one, bro. Shout outs to Audit for the video, man. Make sure y'all go show him some love. Now this one, an officer arrests an attorney. Listen again to what I'm saying to you people. An officer arrests an attorney for defending his client. So this one should be good, bro, because anytime an officer is arresting an attorney, you know the officer needs to be really on point. You know what I'm saying? Whew. This one should be interesting. Let's check it out.
Now let's dive right in and audit the interaction. On February 23rd, 2017, attorneys Victor Revel and Megan Garcia were leaving the courthouse with their client, Lloyd Edwards, after appearing in court in reference to a protection from abuse order initiated by Mr. Edwards' wife, Jasmine. Before leaving the courthouse, Mr. Edwards gave 2 of his 3 cell phones to Mr. Revel. As Ms. Garcia, Mr. Revel, and Mr. Edwards exited the courthouse, they were confronted by Deputy Ashworth and Deputy Ratliff of the Blount County Sheriff's Office in Blount County, Alabama, who were attempting to serve a search warrant of Mr. Edwards and his vehicle.
I'm from the Sheriff's Office.
There we go. Do you have any other weapons on your person at this time that I need to know about? Or safe?
No, sir.
No,
I'm in the car.
Okay. What do you have in the automobile?
A small pistol.
Okay. Your vehicle is also part of this search. Okay. So I'm going to have to ask you, do you have the keys to your automobile?
Yes, sir.
I need the keys to your automobile right now. Okay. Let me pat you down, make sure you don't have any other weapon. Just for your safety and ours. Okay. Just hang tight, we'll get all this resolved.
As mentioned earlier in the video, Mr. Edwards was appearing in court about a protection order issued by his wife. Mrs. Edwards alleged that Mr. Edwards had abused her and their daughter, and testified that Mr. Edwards' cell phones contained proof of her claims. Mrs. Edwards' testimony led the prosecution to pursue a search warrant for Mr. Edwards' person and vehicle, specifically targeting his 3 cell phones. I called the Revel law firm, and Mr. Revel stated that there was no evidence of abuse on the phones, and that the phones actually contained evidence that supported Mr. Edwards' innocence. Mr. Revel claims that Mrs. Edwards had exchanged explicit messages with Mr. Edwards, which indicated that her interactions with him were consensual and that he intended to submit the phones as evidence for the defense. Mr. Edwards later stated that Mr. Revel told him that, quote, "There may come a day when the prosecution wants your phone," and one of the attorneys asked him for the 2 phones just before exiting the courtroom. The phones were then placed into Mrs. Garcia's briefcase prior to exiting the building.
The warrants that you all have are for his person.
That's correct.
And for his vehicle.
That's correct.
So he has given the phone that's on his person.
Okay, I have video of him handing the phone to you. You handing the phone to her. It's in the satchel right now.
Yeah, you all do have that, but that is not on. When you all
No, I'm
came
out
on
here
him
at the courthouse
to serve
with
this
Brian on
warrant,
the search
that was
warrant.
not on his person. So you all are not entitled to that.
Okay. Well, I can. We'll go the other route to get that other phone.
As Mr. Revel mentioned, the language of the search warrant dictates that the...
Yo, do y'all like ever... Like, this is fascinating to me. I love this channel, bro. I love this channel because it's all about wordplay. You know what I'm saying? The wording, how you say something, how it's said, how it's presented, how you go about it, how it's... Like, it's a cat and mouse game that's played, bro. That's... Like, if you pay attention to it, bro, it's exciting to me. I don't know if y'all can tell. You know what I'm saying? How his attorney was able to read that document real quick and rebuttal to say, you presented him for that phone, what was on his, it is not on his person, therefore this is not, like, that's crazy to me. That's crazy to me. But had not an attorney been there, and it just was him and a random woman beside with the phone in her briefcase, would we have known to say that? Would we have known? No, we wouldn't have known. I wouldn't have known. You know what I'm saying? Bro, Like, this channel is teaching you, like, learning the law is key, bro. Knowing your rights is key. Understanding verbiage is key. And I don't like to read. I'm sorry. I don't like to read books. Like, I read articles and stuff like that, man. You pop a book in front of me, I'm sleep time.
Search may be performed on Mr. Edwards' immediate person and vehicle only. Since Mr. Edwards was not in possession of the phones at the time of the warrant being served, the deputies are not entitled to them. If the deputies had acquired a search warrant for the phones themselves, then they may have had some authority to seize them. But the validity of such a search warrant would be questionable, considering that the defense also intends to submit the phones as evidence. The search warrant presented by the officers does not authorize them to search Mrs. Garcia, but the prosecution does have a trick up its sleeve, which we will discuss later in the video. After realizing that Mr. Revel is refusing to comply with the search, Deputy Ashworth calls the district attorney's office for advice on how to proceed.
Hi, we're standing here, and we have it on video that he handed his cell phone to his attorney, one, and they handed it to another, and it's in the satchel that is right here.
Well, are we being detained?
At this moment in time,
They're not denying it, we have it on video.
I'm going to detain you until we determine the next course of action. Give me just a minute.
Well, I have this
Okay.
person and vehicle.
I'm going to turn it.
Yo, body language is everything, right? Body language, pay attention. The attorney has already done put his hands on his hips. He asked the question, am I being detained? You know what I'm saying? He's going the proper route. I feel like he knows how to handle this situation very well, bro.
It's all. I think what we just done.
Okay. Okay, we either need the phone out of the satchel, or we will have to detain you and get a search warrant to get the phone.
So you're going to well, okay. Well, we're not going to give you we're not going to give you anything on our person that you don't have a right to. So if you detain us, you have to have there's certain constitutional safeguards to do that. But if you're going to detain us, then hey, we're not going to run. So you all are telling us we are being detained. Is that right?
At this point in time right now, you are being detained. Now,
Might be a little wrong. He got a little bit shaky in his voice, bro. I was on his side in the beginning when he said it might be entertained, but this time he got a little bit that and am I being detained? All right, I kind of lost a little bit of confidence, but I'm still holding on your side though. But I did kind of lose a little bit of confidence right there.
Okay, you both are under arrest for obstructing government operations.
Obstructing government operations.
That's correct.
This is definitely an unlawful arrest. But we're under arrest. We're under arrest.
Mr. Revel is more than correct that this arrest is unlawful. Not only are the deputies charging Mr. Revel under the authority of an irrelevant search warrant, but neither Mr. Revel or Mrs. Garcia did anything that would constitute a violation of Alabama Code 13A-10-2. The code states that a person commits the crime of obstructing governmental operations if, by means of intimidation, physical force, or interference, intentionally obstructs the administration of law or prevents a public servant from performing a governmental function. Neither Mr. Revel nor Mrs. Garcia conducted themselves in a manner that was intimidating, physically forceful, or interfering. They both simply stated that they would not comply with the deputies' unlawful orders. They did nothing to prevent the deputies from seizing the phone.
Who is this lady right here? Somebody tell me. Because she keeps making a phone call. Like, she's going off of somebody else on the other end of that phone call telling her what to do. She has no idea what she's doing, bro. And she's calling people and then coming back like, okay, you're under arrest. Are you even sure what you're doing? Like, bro, whoo, that's why I say you got to be on your A game, being a police officer or prosecutor anyway. But when you do something like this going against an attorney, you gotta be on your A++ game, bro. Whew. I wouldn't want to be these people right now, bro. No.
Deputies were so sure that the search warrant authorized them to seize the phones, then what was stopping them from taking Mrs. Garcia's bag and getting them? Certainly not Mr. Revel or Mrs. Garcia.
Yeah, this one, right?
I'm not just getting in trouble for it.
Sir, if you would, around with me, make sure you don't have no weapon on you at all.
Of course not.
Okay. Just want to make sure.
We have it on video.
We have not broken the law. So if you're arresting us, I'm being arrested for obstructing government operations.
That's correct.
Let me take out this right here.
If you don't mind, take them copy. That way they'll,
Real life. Y'all want to arrest two lawyers for this charge? You sure you are?
Yo, the girl next to the attorney is like, she might be a paralegal or something. She's like, but I'm gonna trust you. I hope you have something up your sleeve, bro. Like, she's putting the utmost confidence and trust in him right now.
Are you subject to the law? I am subject to the law. Okay. And this is, and who are you?
I'm Sue Ashworth.
Sue Ashworth?
That's correct. And this is Brian Ratliff.
And you're arresting us under her orders? Yes, sir. Okay. Deputy Ratliff, yes, I want to make sure that you know from our position was that this search warrant, this warrant was given to him after he gave us some things for us to use in his defense. And so we did not do anything to keep you all from doing you all's job. Now, if you all want to take this satchel and go through and do it,
at the courthouse.
we're not preventing you from
doing a search warrant on the car.
so I just wanted to make
I'm out here just.
from the moment he's entered the courthouse, he's been under surveillance. Okay? For the reasons of this search warrant. Alright? I'm sitting here and watched you and him and her.
Can't believe we get about 10 or 15 minutes. I'll be ready.
You looked up. Matter of fact, you did look up at the camera 2 or 3 times. He pulled the phone out and handed it to you. You handed it back to him. He was fooling with, I'm guessing, a password. And after a short period of time, he handed it back to you. You handed it to her. She put it in here. Okay? That is evidence for this search warrant.
And you agree with me that you all served this search warrant on him subsequent to that, after that, right?
Yeah.
After we left out the building.
Yes.
The deputies fail to understand the authoritative limitations of the search warrant, and Mr. Revel and Mrs. Garcia were arrested and charged under Code 13A-10-2. The prosecution initially offered to drop the charges if Mr. Revel agreed to write a letter apologizing and admitting that the deputies did nothing wrong, but Mr. Revel rejected their offer and decided to proceed with a trial. In the ensuing criminal trial, Mr. Revel and Mrs. Garcia's defense argued that the state failed to establish the defendant's intent, and that no crime was committed because the search warrant did not authorize the search of Mr. Edwards' attorneys. The prosecution argued that they were entitled to the phones under the exigent circumstances doctrine, which is a legal precedent that allows for warrantless searches in circumstances where evidence has a high likelihood of being destroyed, such as cell phone data. I have covered the exigent circumstances doctrine in a previous video, which I will link in the info card above.
Yo, that girl over there, she is tripping out. How did that come out on my screen?
During the trial,
She is tripping out, like hands on knees. She is like, I ain't never been to jail. Oh, they gonna take my cookies. Oh, I ain't never been to jail. What is this gonna be like? She is tripping out.
Mr. Edwards, who was
She acting like she got drugs in her back pocket.
still under investigation at the time, testified for the prosecution, but stated that District Attorney Casey tried to prep him in his testimony, even though she had reportedly recused herself from the case, and Mr. Edwards became a key witness for Mr. Revel's defense. Ultimately, Judge King acquitted Mr. Revel and Mrs. Garcia of all charges and stated that the deputies were wrong about the authority of the search warrant and that the defendants never physically prevented the deputies from carrying out their duties. Mr. Revel and Mrs. Garcia were forced to recuse recuse themselves from Mr. Edwards' case after filing 2 separate federal lawsuits against Deputy Ratliff and Deputy Ashworth, as well as District Attorney Casey and the Assistant District Attorney Scott Gilliland. It is worth noting that Mr. Edwards has yet to go to trial, and his case has been reset by a different grand jury several times over the past 2 years. It is highly irregular for a district attorney to delay indictment when the suspect has been charged, and there is merit to the notion that she may be delaying Mr. Edwards' prosecution so that she can use his pending case as leverage against him for his testimony in the federal lawsuit against her. Nonetheless, Mr. Revel is optimistic about the case and told me that he expects to reach a settlement agreement with certain undisclosed stipulations. Overall, the deputies and district attorneys of the Blount County Sheriff's Office get an F for exaggerating the authority of a search warrant, violating Mr. Revel and Mrs. Garcia's Fourth Amendment rights, and falsely arresting them for obstruction. At one point in the video, Deputy Ashworth states that she is detaining Mr. Revel and Mrs. Garcia until she is able to acquire a search warrant, and she may have had the authority to do that under the exigent circumstance doctrine. If Deputy Ashworth had stuck to that plan, she may have been able to legally seize the phones, but she instead chose to escalate the detainment to an arrest, rather than waiting for a proper search warrant. The phones were eventually searched by the prosecution, but they did not contain any usable evidence. And even if they had, the prosecution would not have been able to submit them as evidence in the trial against Mr. Edwards because the phones were illegally obtained. The only thing that the prosecution got out of this interaction was a federal lawsuit that will likely result in a hefty settlement. Mr. Revel.
Yo! I have never seen nothing like this, bro. Like, come on. I thought that was rather odd too, for her to say, well, I need to obtain a search warrant, and not even obtain the search warrant, just upgrade it to an arrest. Yep. We're moving it from you being detained to you being arrested now. Whew. This is crazy. Super juicy.
Gets an A+ for having the mental agility and conversational fortitude to dispute the validity of the search warrant and the courage and conviction to defend his personal liberty and stand by his defendant's rights. Mr. Revel immediately knew that the arrest was unlawful and offered the deputies multiple opportunities to reconsider. There is no...
Now that he did do, he kept saying, so you're saying that you understand that you're doing... So you realize that he kept saying it, bro. Like, listen, bro, I'm trying to give you an out. Now he was a little shaky a couple of times, made me kind of be like, all right, bro, do you know what you're talking about? Are you sure? But played it perfectly, man. You can't draw it up no better than that. Touchdown. We just waiting on the extra point. You know what I'm saying? At this point, God bless. God bless.
No doubt that Mr. Revel and Mrs. Garcia will walk away from this case with a victory, and any client would be lucky to have their representation. Mr. Revel deserves recognition for his conduct during this interaction, and I will leave a link to the Revel Law Firm's website in the description below for anyone in Alabama who may be interested in seeking their services. Let us know if there is an interaction or legal topic you...
That was textbook right there, bro. Textbook. Only thing that was scary about this was Mrs. Garcia, just watching her whole body just start to shrivel up as she realized that she could possibly be going to jail right now. She was like, oh, I think her legs started shaking like a little baby deer. Like, oh man, she was rubbing her knees like she... like she was playing sports and she had just ran a 90 yards. She was all over the place, man. If the picture from the, I guess that was a body cam. If the body cam video was any more crystal clear, you probably could have seen the sweat beading on her forehead. Bro, she was messed up, but shout outs to him, man. Played it well. Y'all get at me in the comment section. Let me know what y'all thought of this one. This was a good one. Till the next reaction, man, I'm gone. Peace.